Sure, I would do honestly.
Letting the members have the memorandum, right? Okay, thank you.
Thank you, Chair. If I could just add to what my colleagues have said. It's been mentioned that in Gauteng, for example, the caseload of legal officers is 800 files, which is not really manageable. Also been mentioned that our funding comes in part from the Fidelity Fund. Our funding, in fact, comes from mentioned that our funding comes in part from the Fidelity Fund. Our funding, in fact, comes from registered practitioners and then also from the Fidelity Fund. Now, we have a major problem in collecting levies from our members, principally because we do not have an appropriate regulation or statutory measure that is effective. And what we would like is for us to have the power to suspend the registration of or the accreditation of a practitioner while they are in arrears. It's a fact that since 2019, the Legal Practice Council, and this goes back to before certainly my time on the Legal Practice Council, has from time to time experienced the growing pains of a brand new act. The LPA was a virgin act. It wasn't a successor to another act. The first act that regulates the entire legal profession. And obviously a new act like that is going to experience growing pains once it is in force. And the Legal Practice Council has since 2019, from time to time, submitted proposed changes to the act. And it is my understanding that not one of those amendments has been taken forward by the incumbent Minister of Justice and Constitutional Development. Now, one of those law reforms is the one that constitutional development. Now, one of those law reforms is the one that against members who, although in practice balk at paying an annual levy, which is a fraction of what members of the General Council of the Bar pay to that voluntary association. My levy to the Legal Practice Council is less than 5,000 Rand per annum. It's not a big amount. And yet it is not paid. I pay, but it is not paid by many. The other structural difficulty we have is that the amount that we receive from the Fidelity Fund is an amount determined by the Fidelity Fund in consultation with us. Now, when you don't know from one year to the next whether you're going to get 200 or 300 or 350 million, it makes it very difficult then to take additional staff onto your fixed establishment to act as legal officers and to carry out the other parts of our mandate. So those are two significant difficulties in the path of the effectiveness of the LPC. Thank you, Chair.
Thank you very much for that presentation. I would encourage the members to look at the memo because there is quite a lot of information therein as well. I'm going to ask some questions which are contextual, and forgive me if they sound stupid, but I think they important. And let me say upfront where I am going with this, so that you know. I believe, and you are welcome to disabuse me later, that there is a problem of perhaps a saturated legal fraternity in terms of people that are out there in the system. There are too many lawyers relative to the people that can afford the services of a lawyer. And lawyers are struggling to either find employment or to keep their law firms profitable. And I believe that cottage industries develop as a consequence. In other words, pursuing rough matters exclusively becomes a way in which law firms make money, and pursuing medical legal claims becomes a way in which law firms remain profitable or are able to pay salaries or even of just the founder, him or herself. of that law firm. So it becomes a way to make a living. And that provides a perverse incentive for unethical behavior. That's where I'm going with the questions I'm going to ask you, so that it's clear. So do you have information on what proportion of law firms are profitable, are basically able to pay their own bills, in effect? Do you collect that information?
No, Chair, we don't. And the main reason, Chair, is that when we do the audit, when we receive the audit reports of the law firms, the Act requires us, Chair, to only look at the trust account audit, which looks at the money that is relating to clients only. So that audit does not determine when the lawyer has paid his own fees, how much is remaining for him or her to remain profitable. The law does not require us to look at their business accounts or their business audits.
All right, so that's the first question. The second question I have is, do you have information on either the number of law firms or the proportion of law firms that only pursue these kind of claims? Only, that is, well, the most popular is the road accident fund. Do you have that information? In other words, somebody is a rough lawyer, basically.
That one
No.
also, Chair, I don't think we keep records of that, as to who specializes only in rough matters. Many law firms that do practice RAF matters will also practice, will especially small law firms, or your general small law firm will have many practices. It will not be necessarily a specialized law firm in terms of rough matters. And many other law firms, guy will have 2 or 3 rough matters. So it's very difficult to keep an account as to who does exclusively what.
Okay, thank you. So would I be way off the mark if, as it, for a lay person like myself at least, think that there are law firms that have become expert at handling rough matters, and there is a network of not just law firms, but medical and other related experts they work with all the time, right? In other words, we find a potential claimant, they go to Dr. Mkhize, not our honorable member here, they go to Dr. Mkhize and they go to expert so-and-so, and that a report is compiled. And that between all of these people, it's actually a significant part of their business, generally. Would I be off the mark? And as a linked question to that, have you investigated or at least had insight into the extent to which you have such scenarios? In other words, do you have cases where, and I'm imagining if I'm a judge in Pretoria, where most of these, there's always a medical report by Dr. Matiwane, and in the context of the RAF, because I really took time, I've read about 38 to 40 judgments on SAFLI. In most of the matters, genuinely, the RAF does not pitch, right? That says to me, if I know that, and I'm an attorney, and I know that they might not pitch, I'm always going to go to the same person to give me the same assessment that says a person is potentially going to lose future income of X amount, and I know the RAF won't be there, and we will get the default judgment because they're never there, right? And in that way, even though your report says only X amount, and I'm going to ask my last 2 questions and I'll give the members. it's possible that those who successfully do this actually get to make a lot of money on the basis of what the Contingency Act allows.
No, Chair, I think you are correct. Let me first try and, as you mentioned, disabuse you of the idea of the cottage industries. Yes, there is a significant number of practitioners who enter the field, especially RAF-related litigation. I think it's one of the slightly easier fields to get into. Medical negligence, not so much, because I think that requires a lot more, deeper skill and understanding. But I think you need to take one step back. The reason why those, if you want to call them cottage industries, come into being is because there's a bigger problem in the environment, right? RAF claims cannot exist if accidents do not happen. And we cannot dispute the fact that these accidents do happen, right? And if these accidents do happen, surely the client or the victim does deserve to be compensated. I mean, that's something that's in our law from time immemorial, that you do need to be compensated for the damage that you incur. What level that damage needs to be is a different discussion, and I think maybe that's the one aspect that the CEO of the RAF is really trying to push, is in terms of that legislation, and I'm not going to express my opinion on that. But yes, those industries do come into being. I think the bigger question needs to be, when you talk about, you didn't use the word, but you kind of hinted at almost syndicates developing, right, between legal practitioners, medical practitioners. There might be some of those cases, right? But again, if you look at the statistics that we presented to you of legal practitioners who are struck or suspended because of that kind of unethical conduct, it's really a very, very small number. And yes, from experience, I can tell you that a lot of these claims, especially the RAF-related claims, also present before the Health Professions Council. In the form of the RAF Appeal Tribunal, which looks at the severity of the injuries before the client can be paid for general damages. And yes, you are quite right that you will see the same medical practitioners presenting reports. And as in any other industry, you've got ethical medical practitioners and you've got unethical medical practitioners. The fact that you've got one medical doctor who continuously presents reports does not make him unethical. He saw an opportunity in the market and he took the opportunity. It's business. These are business people. Lawyers are business people. So to say that you've got the same people doing these kind of claims is problematic, I don't think I can agree with that. What becomes problematic is if they start entering into some kind of unethical arrangement. And I know of instances where this has happened, where legal practitioners will tell doctors to amend their medico-legal reports. That is wrong. And those legal practitioners should be reported and should be struck or suspended. But to take an opportunity that's in the market, I don't think there's anything wrong with that.
I can just add to what Ignatius was saying, is that there's a code of conduct on how legal practitioners have to behave and have to comply with. Highest ethical and integrity standards are espoused, and the same goes for the medical practitioner. We would be expecting that. I'm using the same person, but it's not. It doesn't imply anything. It simply means that I trust his or her expertise, and that's why maybe I'll go back to the same person.
Chair, if I may, I think it was the Deputy Judge President Sutherland who commented that the number of matters which are dealt with on an unopposed basis does not assist the process, because if you have medical practitioners appearing regularly as expert witnesses, but there is proper opposition. There's an expert on the other side. There's counsel on the other side cross-examining. Then, if a medical practitioner is not doing the job properly, they will be discredited through that process. But if they're continuously pushing against an open door in the sense that it's only their report and their version, and there's no one there to test it, leaving it almost to the judge to look into the cogency of the opinion presented, that doesn't properly test the expert. But I agree with what my colleagues say, that there is obviously a specialization in people who appear in court, just as there are with accountants. There are many accountants who will never appear in court, and there's some who will appear regularly as forensic accountants. That's not per se a problem. The difficulty is if they are not subjected to proper scrutiny.
Chair, just lastly on your saturation of the legal profession, we do believe that the profession is saturated, and you see this when it's the annual requirement for audit reports. The law firms are unable to even afford the 30,000 to get a chartered accountant to do their audit reports, because the little money that they received, they either pay rent or pay their staff, and you also have a lot of law firms which are asking us to exempt them from submitting audit reports because there was nothing. There's like less than 10,000 that flew into the trust account. So when we get those bank statements and we see that, you know, there are law firms which really don't make any money for many years, and they constantly are asking us to exempt them. But Chair, with that information that we have, the LPA strictly says that our mandate is to enable access to the profession. That has been my problem as the EO, to say we see about 6,700 people sitting for exams every year. Where are they going to get work to sustain themselves? But there's not much I can do about that, even to advise counsel, because the Act says that we must enable access to the profession, and that is what we are doing based on what the Act requires us to do, Chair. Thank you.
All right, thank you very much. So we are going to take a break at some point. My advice to you is that during break, discuss amongst yourselves who's going to handle which questions, because we will be here for a very long time if all of you take a stab at the question, because we also have lots of members here. I'm just going to make a statement and then ask my last question. And that statement is that, so I just forget the judgment, I'm going to find it, that the claimant against the road accident fund was a young person born in the 2000s, had done, I think, N1, N2, I'm not sure, and I'm old now, this in terms of grades. But anyway, this person passes a matric competently. They have an accident when they are in grade 11. The following year, so they submit a claim. The following year, they write their matric exam, and they pass, and they get a tertiary qualification mark, right? I'll say metric exemption. I'm old, sorry. They get a metric exemption. Yeah, okay. Bachelor pass. They get a bachelor pass, right, or an equivalent. And the particulars of claim now state that this person went to a TVET college and did well in their first year. But this claim is continuing, right? There is a medical practitioner who has done an evaluation of this person, and they've said this person is brain damaged, right? And therefore their prospect for earning an income in future are poor. There is no RAF attorney in the hearing. Now the judge is arguing literally is like asking questions. I'm looking at your submission. How can this person do well in their exam and also do well post school? And you are here telling us that their prospects of making an income in future are poor because they are mentally impeded. Which said to me, this was a bogus claim, and that's what the judge, they couldn't sustain the thing, but the submission is there. What I'm trying to get to is I'm not saying people enter into these professions in order to crook the system. I spoke about a perverse incentive. And the perverse incentive is that I know if there'll be nobody to defend the matter, I can make any claim. Chances are it's going to be accepted. Right? That's where I am basing my opinion on, because SAFLI is littered. I would say about 40% of the cases that are there are rough cases. And I've taken time to read lots of judgments, short ones, long ones, all the way to the Supreme Court of Appeal. And this appears to be a constant problem, where the rough does not appear. And some of the claims where the rough does actually argue the matter, the claim is preposterous. So that's the first thing I want to say. The second thing I want to say is that if we assume that in order for someone to lay a complaint with the LPC, they have to know about its existence and its work. And that we can make an assumption that a fraction of South Africans know. The majority of South Africans don't know. And that it is plausible, therefore, to say the cases that you are reporting on are the cases you know about and are on no indication of the extent of the problems that you've... Can we agree on that? That there is no, you can only report on what you know. And if we look at all crimes and cases of misconduct, they get underreported. And that the problem may be bigger. And if we had the tools to examine a sample of 500 cases before the ref, in all, you might find that there is this. And therefore, it is possible that this cottage industry actually exists, where people milk public funds in this way. I'm not accusing anyone in particular. I'm just trying to examine the facts. The last point I want to ask you is pertains to so I've had a look on that encourage members to look. I think it's page 15. Where's that table in the memo? And I noticed that there was an explosion after COVID-19 of cases of misconduct because they went from how many in 2022? Please assist the committee with the dates, the page number. But anyway, and that says to me we now have an exacerbated problem because you ordinarily have law firms that are struggling, then they got affected by COVID and they potentially are struggling even more. We will, let me just give the members an opportunity to ask. The time is 1:30. I want us to take a break at 11. So I'm going to give Honorable Skosana and Honorable Madlala.
Sorry, Chair.
Sorry. Oh, sorry.
Proposal. Chair, can I... Thanks, Chair. Good morning to colleagues as well and LPC. Chair, I just want to make a proposal that I think it will help us to manage time. I'm not sure, Chair, but I wanted to propose that why don't you give each member maybe, let's say, 10 minutes. If you count that, it should be about 2 hours and 10 minutes, the exchange between them and LPC, and then we move on so that we don't lose questions in between. Thanks, Chair.
Proposal accepted. So what we will do is we will give Honorable Skosana and Honorable Madlala. So here's how we'll do it. So Denzel is going to start timing. You get an opportunity to have an exchange with the LPC. So the 10 minutes is not for the asking. The 10 minutes is for the entire conversation. How many questions you manage to get in has to do with how concise you are with your questions. One, and secondly, may I please ask colleagues, amongst yourselves, you need to pick. Otherwise, the members are also going to get frustrated when the answers come from many different people. Is that okay? Can we proceed on that basis? Thanks, Honorable Maduna. Honorable Skosana, your 10 minutes begins now.
Thank you, Chair. I'm sorry that I came a little bit late here. But be that as it may, we are again back to the road accident fund issues, which reminds me of some time ago. If you remember, Chair, there was Ian Stokes who left with millions of rands. Investors put money into his account. He was paying claimants in advance, and a percentage. You make a claim at REF, he pays you because he knows that you sign that you will be paid in a year or two from REF. Then we'll pay you the remainder, around 16%, if I remember well. Now, is it Ian? Is it Ian, if I remember well? I'm sorry? Ignatius, yeah. I've listened very attentively. It's unfortunate that the LPC as well dominated by the JCB. LPC has just become
sorry by that, J? Yeah?
GCB.
GCB.
Yes.
What is that?
They'll answer. They'll know what I'm talking about.
No, remember.
I will tell you.
Okay.
It's General Council Bar.
Okay. Yeah. No.
Yes.
I always do that when
okay.
there's an abbreviation.
Okay, thank you.
Yeah.
No.
Because we streaming.
Sorry, Chair. LPC has become another terrain used to settle scores and target legal practitioners, advocates that are outside the fold of GSCP. What happened when this LCP started? Mainly dominated by GCP members, in particular whites. Why did the LCC condemns Pabasa for certain charges against Mpofu? I'm talking about the recent case, when themselves withdrew for the same reasons. Chair, where I'm going, in South Africa, there's a settling of political scores here. Among other things, jealousy as well. I'm going to be frank. Is the LPC not entirely composed of GSCB? That was my question when I mentioned this. Of advocates to the exclusion of advocates from other bars association. Is this not compromising its integrity as a regulatory body? What do you say to the accusation that LPC is colluding with JSC to ensure that association like Pabasa and the National Bar Association are excluded from JSC so that only advocates from the GCB can be involved in the appointment of judges? The LPC seems to be slow to pursue charges against white advocates and quick to pursue charges against black practitioners. What happened to the charges against Helen's SC and Jubed SC convicted of lying to the Namibian authorities? Is it true that LPC has not finalized its procedure regarding the silk recommendation and that it seems to recommend only those from the GCB? Now, let me just ask this as well. The issue of REF, when I look at the presentation which we received, these 101 or 102 firms, why they were not named on this presentation? Why they were not named? And I can tell you, it's for one reason. They are protecting big firms here. The issue of medical claims and the issue of lawyers, as Ignatius was saying to us here, that some of them paid back the money, that 350 million which was erroneously being paid to them. I'm not buying that. If only the numbers which they gave us here, that no, some of them, the double payment was, I mean, it's ethical for you, before even being pursued, to pay back the money, because you can see in your account that there's money which you don't deserve. Those duplicated payments, we know what happened. Some big fish were involved here. Some of them, I'm seeing, I saw that there's 10 of them or so. And the issue of I think one of my colleagues asked about the interest. And the answer is not convincing, unfortunately. You know, that lawyers are business people. Yes, be a business person, but be ethical. Be a business person, but be ethical. And there's a lawyer for that matter. I mean, we've seen judgments in this country which leaves much to be desired. We know for a fact that sometimes judges think that they are, in fact, they are law unto themselves, some of them. I'm going to be frank here.
Honorable Skosana, so I'm not stopping you. I'm just giving you a time warning.
Yes.
Because
I'm aware.
you need to get proper answers, right?
Thank you, sir.
And we're going to run out of time, and then it's going to be a problem.
Yeah. Let me finish by saying, to the Legal Practice Council, that it's unfortunate that the milking cow is road accident fund for even these so-called big firms, you know, like your Wenzel and Weber, you know, who've got almost 500 lawyers or attorneys, and these Bowmans and Bowmans or whatever the name is. But I'm still saying, Chair, that please, in this presentation, they must name these lawyers, these firms. Thank you, Chair.
Thank you very much. So we invited. Thanks.
Sorry, Chair. Sorry, Chair. My last one. Sorry, Chair. What is the use of chasing lawyers who are not practicing in law, who are not practicing in any bar, and say you want to strike them off the roll? Thank you, Chair.
Thanks very much. So I'm going to say we invited the LPC and we'll stop the clock. It's at 8 minutes. So I invited the LPC here for two specific reasons. And I'm not saying they shouldn't answer the question. If they're comfortable to answer it, they can. Because we took two presentations, or in one session in this room, with the health minister and the health committee about medical legal claims. The second, we've had numerous encounters with the Road Accident Fund on precisely these matters that we're talking about. We then agreed in that meeting that we will call the LPC to account. In my briefing to the LPC, I asked them to focus on those two matters. I'm saying this because in the early part of your questioning, you focused on issues pertaining to Advocate Mpofu, I'm assuming, and so on. I never asked them to prepare for that. I think it falls outside the brief of what we've said, but if you're comfortable, you're in a position to answer that question, please do. I just don't want to come across as protected. I just want to be clear about how we got here, Honorable Skosana, but I won't direct them on whether they should answer. If you're competent to answer that question, please answer that question. Thank you.
Thank you, Chair. I think I will answer most of the questions by Honorable Skosana. The LPC is definitely not dominated by the GCP Chair. And I say this because on my opening remarks to the committee, I did clarify that out of the 23 council members who make up the National Council, only 6 are advocates. So if you do the maths, you then have 17 who cannot be a member of the GCP because they are non-advocates. That's the first point, Chair. The second point is that other bars are excluded. That's not the case, Chair. The election of the provincial of the council members, either for national or provincial, is a democratic election, every practicing legal practitioner is allowed to vote and or to nominate and also to vote for the member they want to be either on the National Council or the Provincial Council. Chairperson, on the issue of the collusion with the JSC, I am not aware of such a collusion, Chair. I am aware that there was a complaint by Papasa that we need to come up with the rules of nominating LPs who need to serve on the JSC, because the status quo has always been some members of the advocates profession to be members of the JSC. We have actively, although maybe it could have been delayed, Chair, put together a process where those members who go and represent the legal profession at the JSC will be a nomination and an election by the members of the legal profession. So the only thing, Chairperson, is that that process has not yet commenced. I understand, Chair, that the matter of LNSC is still under investigation, but I will not speak on that because that is a provincial council matter. But I know that the complaint was received and it is being investigated. The silk recommendations procedure, Chair, the status quo has been going on up until last year when we submitted the criteria for the nomination of people to become silks. And that now included attorneys becoming senior attorneys. The problem that we had, Chairperson, which we have sent numerous times to the minister, is that on the new panel that is proposed on the criteria, there was a member of the panel was supposed to be a senior attorney. And if you look at the past, we've never had anyone becoming a senior attorney. So we then said to the minister, can you please appoint 2 people to become senior attorneys so that we are able to then implement the process of nomination and recommendations of silks people. But that process, Chairperson, has been delayed at the minister's office and not by the LPC. If that recommendation to the minister had been implemented by the minister, Chair, we will be running with the nominations and recommendations of members that are requesting to become silk as early as this year in 2025. The names of the LPs or law firms, Mr. Skosana, which were on the list, this list we received in 2020. It's a list which we dealt with 4 years ago. We will have to look for that list, and we can definitely provide it to the committee. And lastly, Chair, we don't strike off non-practicing lawyers. And if there is any instance where the Honorable Skosana is aware of, please let me know, because then we'll have to look at the reasons why they were struck off. Non-practicing legal practitioners, Chair, do not pay levies, and they are barely brought to us as people who have conducted any misconduct. Barely. But if there is any non-practicing lawyer who's brought to us, we do investigate. But I don't remember in my 6 years at the LPC, Chair, where we struck off a non-practicing legal practitioner. Thank you, Chair.
Thank you very much. Honorable Skosana, your 10 minutes is expired.
No, I want to just make a follow-up one, because I don't want to be misquoted, Chair.
You want to make a correction?
Yes. I just wanted to make a correction. No, it's fine. Madala is fine. Yeah. Oh, you can borrow me. Thank you. Thank you, Mr. Waduna. Now, the issue, Chair, which I've raised here, as I said, like he's answering the issue of Helen's and Jubed. To say the matter is being investigated is not enough for me. I'm honest on that, because I've been hearing this thing, as I was saying, in other committees, that some matters are being investigated from 2011. There's no time frame, there's nothing. And in fact, as I said, I'm sorry I came a little bit late. I don't even see the chairperson of the Legal Practice Council. Maybe they've explained why. And the deputy is not here as well. Mr. Selega is not here. I'm not sure whether the deputy is here. I'm just saying, those are the issues that we have to be taken serious, Chair, as well. Because I guess that in all the people who are being called to come here, they come here with their chairpersons. You know, for me, or a deputy, for me, I'm not sure why the perhaps they've explained earlier. Thank you.
Okay, Honorable Skazana, thank you. So I had actually a meeting with Advocate Selega. If he had been here today, so he's acting as a judge. So if he had come here today, that matter would have had to be postponed for a significant amount of time. And we cannot postpone this hearing until such time that that one person is here. Because we'd already postponed already. They were supposed to be here earlier. So he's acting he's sitting on a case today as we speak. That's the long and the short. Thanks, Honorable Skosana. Can I go to Honorable Matlala?
Sure, I would, Your Honorship.